going to give you an overview of the legislation managed by the Ministries of Mining in Canada's three largest mining provinces, Ontario, British Columbia, and Quebec. So just before we get into the legislation, let me give you a little bit about the mining context in Canada. Mining has been taking place in Canada since the 18th century. The first mines in Canada were in southern Quebec near Trois-Rivières, and also coal mining in the Cape Breton Highlands right there. With large-scale immigration in the 19th century, that's when mining really began to boom across the country. But you're probably familiar with the famous gold rushes in British Columbia and the famous Klondike gold rush in the Yukon Territory in the late 1800s. In the early days, it was a time of open prospecting and no regulation to speak of in terms of how people looked for placer gold, for example, in the Yukon. The very first laws in Canada governing prospecting were written in around 1865. Governments in Canada recognized the importance of mineral development to a new and growing country early on. The first legislation creating the Geological Survey of Canada was passed in 1877. Discovery of gold and base metals in Ontario led to the country's first major mining act in 1906. So since then, for the last 115 years, Canada has evolved to be one of the largest mining nations in the world. Let me give you a few numbers to illustrate that. In 2015, the mining industry contributed 56 billion Canadian dollars to GDP. Mineral production in the same year was valued at almost 43 billion Canadian dollars. Mineral products represent almost 20% of Canadian exports by value. All provinces and territories, as you can see from this map, except tiny Prince Edward Island here. And as probably you know, perhaps the most important mining event annually in the world is the PDAC conference in Toronto, in which Mongolia is an active participant. So you can imagine that over the decades, the structure of the mining industry in Canada has evolved considerably, as has the legislative framework, and that's what we're going to talk about today. So I'd like to give you a flavor of what we'll be walking through this morning. I'd like to describe the political context in which Canadian mining legislation is administered, and then we'll work our way through the mining cycle. We'll work through from the first stages where claims are staked out in the wilderness and prospectors begin to look for mineral deposits, and we'll work right through the process up to and including rehabilitation and closure after a mine is closed and the land is rehabilitated, and including legislation that was passed only 2 years ago to better make revenues and payments within the mining industry more transparent. So as you will imagine from your knowledge of Mongolian mining legislation, the amount of legislation that we can talk about is actually huge. There have been entire books written by lawyers about legislation in any mining country. We can't cover all 12 mining jurisdictions in Canada this morning, so I have chosen to focus on 3 provinces, Ontario, Quebec, and British Columbia. And I've chosen them for 2 reasons. First, because simply they're the 3 largest mining jurisdictions in Canada. But secondly, because I think that each of those jurisdictions has done some innovative things in their mining legislation over the last decade. And I'm also going to focus today on legislation that's administered by the mining regulatory authorities. So I will not, for example, be talking very much about important environmental legislation in this sector, nor will I be talking very much about important tax legislation in this sector, which typically are managed by other ministries. As we go through this, I'm going to try to identify what I believe are areas of international good practice in modern responsible mining, based on lessons learned in Canada. So let me describe a little bit about the Canadian context, which is important to understand in order to understand how Canadian mining law has evolved. In most cases, mining laws are managed not at the national level, but they're managed at the provincial or IMAG level, and that's because of how the Canadian Constitution is written. So it makes it a little more complicated to understand the Canadian mining law framework, particularly for investors, but on the other hand, it allows you to see a range of approaches across the country, some similar, some different. Like Mongolia, mineral resources under the surface are owned by the people and managed by the government on their behalf. So that means that in Canada, governments have a responsibility to manage those mineral resources on behalf of the entire population. In Mongolia and in Canada, there's a history of different approaches that governments take to manage those resources. And those can include extraction of the resources by private companies governed by law, or they can include extraction of those resources by public companies owned by government. In the 30 years that I've been around the mining industry, there have been a very small number of cases where the mining company is publicly owned, that is to say, by the government. But in the vast majority of cases, the companies are private. Private, either personally held or private in the sense that they get their financing from stock exchanges. And the logic of private extraction of mineral resources in the vast majority of cases will probably not surprise you. It's because the technical nature of mining and the experience that companies have in extracting minerals and the access to financial resources they have, in each of those cases, those areas, they exceed the skills of government. They exceed the capacities of government. And so in other words, and to slightly oversimplify, governments do what they do best, which is setting the rules and enforcing them, and the companies do what they do best, which is obtaining the capital and applying the advanced technologies to extract the ore. So in the context of the government role with respect to mineral development, it's important to understand that for Canadian legislation, there's the concept of ministerial accountability, which I will explain. The concept, in simple terms, is that the ministers for each of the departments, for example, the Minister of Mines or the Minister of Environment or the minister responsible for the regulatory authority, that person, that elected person, is accountable to the public for all the decisions that are taken within their organization. So that minister must defend the legislation and defend the choices in the legislation in public places, for example, the Parliament or in public meetings. And like Mongolia, Canada is a democracy, so governments are accountable to the public in various ways, not least of which elections. And that accountability has influenced, over time, the design and structure of mining legislation. To illustrate in a little bit more depth, this chart will probably be very familiar to most of you. This is a representation of the mining life cycle. We'll be talking about legislation across all five. Before any permits are issued by government, there's legislation applying through prospecting, early exploration, and advanced exploration. After the permits, where there's an economic ore body and there's a decision by the company to proceed, after the permits are issued, legislation applies to the development, to the production, and throughout the process, the management of the environment around the mine, including closure and site rehabilitation. I won't be saying much about these aspects this morning, but you will notice that through this phase, which can be a period of years, there's ongoing consultation with stakeholders, and beginning after early exploration right through to the permitting, there's also environmental studies and feasibility studies. In Canada, feasibility studies are typically done by the companies, by the project proponents, under very specific rules set by government, and those feasibility studies are necessary to demonstrate to the finance community, to banks and to stock markets, that the project should be lent money because it's viable and will be profitable. Similar to Mongolia, throughout this process and in parallel, sometimes coordinated, are environmental studies, particularly environmental impact assessments and environmental protection requirements, in particular around effluents and protection of waterways and management of tailings ponds. So I think it's evident from my brief description of how legislation is linked to the mine cycle, that this is one of the most heavily regulated industries in Canada. So the first step is prospector licensing. Now, if you think about prospecting, this is an activity that has remarkably evolved in the last 15 years around the world. The image you will have of a prospector is an individual in rough rural clothing who goes out into the field and stakes a claim, X hectares by X hectares, marks the land and says, this is a place where I want to look for mineral deposits. You will understand, because it's equally true in Mongolia, no prospecting equals no mining. So governments in Canada, historically, and to a large degree now, very much encourage prospecting by individuals without putting up too many legislative barriers to that activity. This is basic geoscience, relatively low environmental impact, and it's done by geological surveys, government organizations, and even more importantly in Canada, it's done by individual prospectors, who may be individuals privately employed, or they may be employed by larger companies. In all three provinces we're talking about today, prospectors require a license. But a license is pretty easy to get, and it doesn't cost very much. For example, in Ontario, it costs $25 a year. It's like a driving license. So the way that prospecting licenses work is you get a license not for a specific area, but you get a license from the government that allows you to prospect wherever. So it just means that you're free to go and do prospecting, and in some cases you need to pass a test, like a driver's license test. In some cases it's even easier than that. So the restrictions are not at the stage of the prospecting license, they come later. So the driving license analogy is a good one. The government giving an individual a prospecting license, the government can also take that license away, revoke it, if the prospector violates the rules, just like the government can take away a driver's license if you violate the rules of driving. So we're not yet talking about a specific area being staked, we're talking about the right to do the staking. So up until fairly recently, prospecting licenses were rarely revoked, and there were very few conditions imposed by governments to get a license because they wanted to very much encourage prospecting. But things are changing now. Governments are expecting more responsible behavior by prospectors out in the field. So in Ontario, which is the interesting example I want to focus on, they've now introduced a Mining Act Awareness Program, which is an online test, like a driver's license test, which an individual must pass in order to obtain a prospector's license. What happened in Ontario is there became more and more cases where prospectors were out in the field and the ways they were doing their work or the ways they were interacting with the local people were causing conflicts because those prospectors were not aware of their responsibilities. To give you an idea of the contents of this 60-minute test, it would include such things as how to consult with communities, how to work with private landowners, so that remember that prospecting is subsurface, but there could be surface landholders who are not the government, so the people have to get along according to rules. So the 60-minute online test includes questions about knowledge of the Mining Act and regulation in the province. It also includes questions on the individual's knowledge of the PDAC, Prospectors and Developers Association, E3 Plus program, which is Environmental Responsibility and Exploration. This is the famous free entry principle. Now, the latest, most important development is you can now stake a claim online at your laptop. with a username and a password. You can see what areas have already been staked. You can see which areas have not been staked. And if you think that there's geological mineralization potential, you can stake a claim right online. Online staking is relatively new in Canada. It's only being implemented in Ontario this year, 2018, although they started as far back as about 2013. So it's taken 5 years to go from the transition to the classic claim staking management process to the online process. About half of Canada's jurisdictions, including both Ontario and British Columbia, have online staking management systems. Quebec does not. In Quebec, under their minimum tenure regulations, it's still physical claim staking, but claims are renewable by the government every 2 years, and in certain circumstances, special provisions apply. For example, there are special provisions for claims that are staked near municipalities, near bugs, for example, and there's also prohibitions on staking claims within 20 meters of larger water courses. You stake the claim and you've registered that claim with the government, and now it's time to do the exploration work to determine whether the promising geology that you've seen is actually good enough to develop a mine. In most jurisdictions in Canada, an exploration permit is required from the Ministry of Mines, but not in all. The principle, however, that applies in all the jurisdictions is that if you have a claim staked in good standing, you have a right to explore that. The government can't stop you. So in Quebec, for example, you do not need an exploration permit. However, what you are required to do is submit annual reports to the government that detail specifically what you're doing, what geoscience you're doing, and what land disturbances that you are causing. In all jurisdictions, this reporting is important, and it's important because you are required, and I will get into this in a minute, but you are required to do a minimal amount of work. You can't just sit on a claim and do nothing. So, for example, in the province of Quebec, your rights to the claim are revocable by the government. They can cancel it if 10 years pass and you do nothing. In British Columbia, the case is interesting because for purposes of the Mines Act, they define mine to include exploration. So all the features in the Act include the exploration phase before producing mine. There, in that province, a permit is required for mineral exploration, and it's extendable only once. But I draw your attention to Section 10 of the Mines Act, which I have printed on this slide in the last bullet. The concept that's embedded in law is the following, and this applies to exploration. As part of the application for the permit, there must be filled with the government, the inspector, a plan outlining the details of the proposed work program and a program for the conservation of any cultural heritage resources and for the protection and reclamation of the land, water courses, and cultural heritage resources affected by the mine, including the information, particulars, and maps established by the regulation of the code. So I want to emphasize that it's not a case of the government telling the exploration companies how to do their work, but the government is insisting to know what they're doing, and if what they are planning to do is not consistent with the Act or regulations, the government can intervene. In Ontario, an exploration plan must be submitted, and the government may issue an exploration permit subject to the Ontario mining exploration regulations. The system in Ontario then is actually quite similar to the system in British Columbia, but there is an interesting feature that I want to draw your attention to, and that is that in Ontario they make a distinction between early exploration and advanced exploration. In the case of early exploration, that involves, as I've written here, clean, safe, clear roadways, access to the site, and a commitment to reclaim land and materials. Early exploration does not require an exploration plan. However, in the case of advanced exploration, an exploration plan is required in order to get permit. And as soon as you start using generators, mechanized drilling or trenching and stripping or any line cutting, that's a trigger for an exploration plan. This is partly response to Uzi's question. But two important objectives of the exploration permit in the Ontario context are to ensure that there is adequate notification and consultation with local communities, particularly Aboriginal communities. Also, in both Ontario and in British Columbia, in the case of advanced exploration, it also triggers closure and rehabilitation requirements. So a closure plan is required for in the case of advanced exploration, as is public notice of your activities formally, as is progressive rehabilitation of the land as the exploration work continues. So a central element of the exploration phase of regulation, the regulation of the exploration phase in Canada, is the concept of assessment work. This is a bit of a difficult concept to translate, but the notion is that for each year that you are doing exploration work, you must do a minimum amount of work to further delineate the deposit. And if you don't do that work, you need to pay the government in lieu of not having done the work. And the important point to understand about the way that assessment work is managed is that the amount of work that you're required to do as an exploration company increases with the number of claims that you hold, and also it increases with the time over which you hold those claims. So in the case of Quebec, for example, and I won't bore you with the details of the regions there, but you can see that if you only held one claim and you only held it for a year, the minimum amount of work required is very small, $48. But if you hold a claim for over 7 years, and you have more claims, it can be $3,600 for every claim that you have. So the costs get quite expensive if you don't do the work. So again, these assessment work reports are not intended to be onerous for serious exploration companies that are doing proper exploration work. But if the work is not being done, the cost of inaction gets high. So that in the case of Quebec, if you don't do the work, the payment that you must make to the government is double what the minimum assessment work requirement for a given year would be. In Ontario, same concept exists. There, under law, the minister is allowed to terminate a claim if work conditions are not met. After year 2 in Ontario, the exploration company is required to submit a geoscience assessment of the potential of the deposit, and the ministry may reject assessment work reports in the case, for example, of fraud or incomplete reporting. In British Columbia, the assessment work requirements are spelled out in the Mineral Tenure Act regulations, and if that work is not done each year according to those regulations, a payment to the government double the minimum exploration work must be made. By way of a summary of these regulations, annually the exploration company needs to provide an itemized cost statement of what they've spent for exploration. They need to have the land properly surveyed by a legal land survey. They need to describe in detail the work they have done and the results they have achieved, any material that has been removed, and in addition to reporting on this information, the report must include a formal statement describing that the qualifications of the geoscientists submitting the report meet the requirements of qualified person under Canadian law. So those requirements, you may be familiar, are 43101 in Canada. For example, in Australia, it's the George Standards. So let's shift to mine permitting. You've done your advanced exploration. You've completed your feasibility study. You've obtained financing through stock markets or other financial mechanisms based on feasibility studies, and you've completed your environmental assessment and other permitting requirements. Now, before you proceed to operate a mine, you must obtain a valid lease for the land. So you actually are leasing the land from the government. and you must also have permits from the ministry and permits from any other government departments, government ministries that may be implicated in the mining process. So the most obvious example is the Environmental Assessment Act permit, but there can also be permits, for example, impacting on transportation, if you're using heavy haulage trucks, permits for handling of explosives, permits for forest clearing. So the important principle from a Mines Act perspective here is that if you've done advanced exploration and you meet the requirements under law and the various permits that I've described, then the Ministry of Mining cannot arbitrarily deny a permit. So the language in Quebec law is helpful to understand this vital security of tenure concept. So if you look at the third bullet on this slide, the minister shall, not may, shall grant a lease in respect of a parcel of land that is subject to claims if the claim holder established the existence of indicators of the presence of a workable deposit, meets the condition and pays the annual rental. So those conditions vary from province to province, not by a lot, but they vary. In Quebec, the conditions include an environmental rehabilitation plan and, quote, a report describing the nature, extent, and probable value of the deposit, certified by an engineer or geologist who meets the qualification requirements under regulation, and a project feasibility study, as well as a scoping and market study as it regards processing in Quebec. That's the second last bullet on this slide. Now, in Quebec law, there's a couple of interesting features. The company is required to do public consultation about the project, to hold a public meeting, and submit the results of that public meeting to the minister. The proponent is also required to create what they call a local monitoring committee, which is independent of the company, so not overly influenced by the company. And that local monitoring committee must include some mechanism to resolve disputes that might arise as the project proceeds. And in Quebec, the law says that the government may require companies to maximize the economic spin-offs for the province from the development of the mineral deposit. The concern there is that once the ore is exhausted, the wealth stops being generated, the community goes back to its original place with less economic activity. And so the government may require the company to show that they're using Quebec suppliers and there's other economic spin-offs from the mining activity. In practice, as you probably know, obtaining economic spin-offs from mining operations, particularly after the mine closes, is difficult. So the government will not always impose economic spin-off requirements. It will depend on the nature of the mine and the location. In British Columbia, mine permits are issued by the Chief Inspector of Mines in the Mines Department. And the interesting feature of legislation in British Columbia is that regional advisory committees are created by the Mines Ministry to advise the Chief Inspector of Mines on issues that may arise. And the regional and the Chief Inspector of Mines is required to set up those committees as a condition of issuing a license. The requirements in British Columbia are generally similar to the ones in Quebec that I have described. However, in British Columbia, the company must develop a detailed mine plan as a condition of obtaining that initial permit. And those mine plans, recovery rates, mining methods, technologies, etc., management of waste rock, those mine plans must be maintained in an updated fashion and be accurate every 3 months. So just to be clear, the initial mine plan must be submitted to the government as a condition of obtaining a permit, but the updated mine plans do not need to be submitted to the government. They must be kept up to date at the mine site, and government inspectors can review them when they want. Under the Act, all mines are subject to the province's Health, Safety, and Reclamation Code, which was only just recently updated, and it's considered one of the best health, safety, and reclamation codes in the world. In British Columbia, there's a separate act to govern the permitting of coal mines, and incidentally, there's also separate acts in Canada to govern the permitting of uranium mines. So under the Coal Act in the province, you require a license to explore or develop a coal resource, and you need a lease to develop or export coal from the province. So the license, which obviously applies to advanced exploration, is valid for 1 year. It's renewable, and it includes annual reporting requirements on exploration results, including resource and reserve estimates. You will require a lease on a coal mine property in order to develop a full coal mine and to export coal. These leases are valid for up to 30 years, obviously dependent on the size of the deposit, and can be renewed once for an additional 15 years. There are fees in the case of coal leases, as there are fees in the case of leases with respect to other commodities. I've mentioned the fees on this slide, but of course the fees are small in comparison to the taxes and royalties that are due. I thought it would be interesting to show you an example of what information is required to get a coal lease in British Columbia. So detailed maps to the 1 to 50,000 scale are required, detailed information on the nature of the coal seams, estimates of reserves properly illustrated, and exploration and development plans for the short and long term. So in Ontario, mine permitting, again, the security of tenure concept, a mining claim holder who has followed the rules is entitled to a mining lease. The term of the mining lease can be up to 21 years. So you can apply for a lease in Ontario only after you've done a certain amount of the assessment work that I described earlier. And Ontario, unlike the other two jurisdictions, is quite specific about that. If you obtain a lease, any renewal of that lease depends on making, quote unquote, a reasonable effort under law to bring the property into production. And like Quebec, there's a concern in Ontario that there's a lasting economic benefit from the mineral development. So there's a provision in the law that mining rights, mining leases, are subject, quote, to the condition that all ores or minerals raised or removed therefrom shall be treated or refined in Canada. So this is a concept that if you extract minerals, the expectation is that they would be smelted and refined and developed into metal products, for example, in Canada. And so that's what the law permits. In practice, this is, in fact, easier said than done. So because of economic conditions, so that requirement can be waived by government, depending on circumstances. And there's exceptions to areas that can be permitted for mining. And amongst the most interesting exceptions are where the forest resources are considered to be valuable for other purposes or to protect navigable waters. I want to make a couple of remarks about rehabilitation and closure requirements. And there's a stream of the CESMIM project that deals specifically with rehabilitation and closure. So in all three provinces, rehabilitation and closure provisions are integrated into mining acts. And the policy point here is that the end of extraction, the closure of mine, does not mean the end of legal obligations for the mine leaseholder. In British Columbia, there was a very high-profile tailings dam break 2 years ago at a mine called Mount Poly, which I will show you in a minute. So as a consequence of that, the reclamation and closure requirements in the province were strengthened in 2017. The provisions in the newly updated code are summarized in these 4 bullets. So a closure plan is now required as part of the original lease requirements. During the life of the mine, there must be a program of environmental protection and reclamation, and it must be carried out during the mine life. The Chief Inspector of Mines has to approve the reclamation plan, and all water courses must be recovered to their original capacity. And the companies are expected to pay for all of this although this is imperfect because cost estimates in this area are difficult. But financial assurance must be deposited with the government, as you can see in the final bullet here, for mine reclamation and to provide for protection of and mitigation of damage to water courses and cultural heritage resources. Just a moment on the Mount Polley tailings dam spill. It's located about 6 hours driving north and east of Vancouver at the Mount Polley copper gold mine. You can see in this map, there's the mine, there was the tailings dam. The dam broke, despite regulations, the dam broke and released huge volumes of contaminated materials into this lake. Happily, this sort of occurrence is very rare, but it was serious enough that it triggered an investigation by the Auditor General of the province and a rewriting of the Reclamation Code. I want to focus here on their financial assurance requirements, which are very clearly stated in law. So you can see the list in the long bullet here of what financial assurance must cover. Rehabilitation, restoration, soil stabilization, securing of openings and surface pillars against any entry by unauthorized people, water treatment, and any reclaiming of roads that may have been built. And also infrastructure to prevent the kind of damage like I described at Mount Polley. So over time, the minister has the authority in law there to increase the amount of financial insurance required of the company, and if necessary, the government could begin work on reclamation and send the bill to the company. So in practice, this would not happen frequently, but the point is that there is the authority in law, if necessary, to take these additional measures. I thought it would be useful, as we near the end of my discussion, to talk a little bit about what some of the reporting requirements are that are imposed by government in the regulations across the mine life cycle. In the interest of time, I'm not going to read these. You can read them yourselves. But I would like to emphasize a couple of points. The operating plan and the environmental management plan go hand in hand. These reports are required, they're detailed, and generally speaking, they are made public. Also, the plans must be prepared by people who are officially qualified to do so. So, for example, legal surveys must be prepared by legal survey companies, and mine plans must be prepared by qualified geoscientists as defined, for example, under the engineering and geoscientist law in British Columbia. And I think it's probably worth emphasizing that one of the aspects of mineral development that the governments are concerned about in Canada is water management. Whether that's the quality and amount of use of groundwater in a mining operation or the protection of surface water and water courses, again, during a mining operation. I want to spend a minute on inspections and enforcement, because laws are fine, but they don't have meaning if they're not effectively enforced. In Canada, and I think this is different than Mongolia, generally speaking, inspectors and enforcement officials are employees of the mines ministries, or in the case of environmental law, of the environmental departments. There's not a similar organization in Canada like GAZI. Under law, official inspectors may enter mine sites at any reasonable time without notice, and they are also protected under law from being sued by companies. Typically, penalties are financial, and as you can see, they can range from up to 300,000 Canadian dollars in Ontario and up to 6 million Canadian dollars in Quebec. As you would imagine, in general and in Ontario specifically, inspection requirements are more important at the mine production stage than they are at, for example, the claim staking stage. So the government rarely inspects claims, but under law, they, as I said in the bullet, they may challenge the validity of a mining claim at any time. And inspection powers in Ontario are quite broad. For example, specifically in law, inspectors can lawfully obtain access to computing devices, computers and laptops. In British Columbia, the Chief Inspector of Mines has the authorization to stop work immediately Serious violations of the mining code are identified by an inspector. There's a strong focus in the province, particularly on health and safety and reclamation, and also verification that the companies are following the procedures that they're required to under law. And under the law in British Columbia, the Chief Inspector of Mines must establish local advisory committees so that a range of stakeholders may provide input into regulatory decision-making and inspections. The interesting feature of the Quebec law in the cases of inspections or enforcement is that the law authorizes the minister to conduct inquiries on any aspect of the Mining Act. The next slide I have is on transparency. It's an important issue, but I'm going to skip the slide because Mongolia is a member of the Extractive Industries Transparency Initiative, and I don't think I want to add a lot more to that excellent world-class process. The reality is that the requirements under EITI are actually more strict than under Canadian law. So let me conclude by drawing some observations about Canadian legislation over its history. The first is that we're seeing a strong trend in Canada towards streamlining of government decisions and the collaboration of relevant ministries in making the decision-making process as efficient as possible. The requirements in Canadian law for consultations and engagement with local communities are much stronger now than they were when I started in the sector 30 years ago. Likewise, with respect to environmental protection, we are really seeing a recognition of the importance of reclamation and closure so that mine proponents return the land to its previous state to the extent that that's possible. And a huge development in the last decade, because of the fact that we all have these, is far greater delivery of services by ministries online, which means digitization of claims processes, digitization of mineral titles information, and reporting of contracts meet transparency. So the challenge that legislators wrestle with every day in Canada is to balance achieving the public interest on the one hand and providing good conditions for investors on the other. The Canadian legislation is certainly far from perfect, but if you judge by the Fraser Institute rankings, Canadian jurisdictions are, I think, doing a pretty good job of finding that balance. So I think the principles and the issues that Canada is addressing and that Mongolia is addressing are actually quite similar. Very nice short summary of Canadian mining law at this website, which is prepared by the ICLG law firm, and I invite you to look at that. You may be aware that ICLG does chapters on mining legislation in all important mining countries, and they also have a chapter on Mongolian mining legislation as well. So let me conclude by drawing some observations about Canadian legislation over its history. The first is that we're seeing a strong trend in Canada towards streamlining of government decisions and the collaboration of relevant ministries in making the decision-making process as efficient as possible. The requirements in Canadian law for consultations and engagement with local communities are much stronger now than they were when I started in the sector 30 years ago. Likewise, with respect to environmental protection, we are really seeing a recognition of the importance of reclamation and closure so that mine proponents return the land to its previous state to the extent that that's possible. And a huge development in the last decade, because of the fact that we all have these, is far greater delivery of services by ministries online, which means digitization of claims processes, digitization of mineral titles information, and reporting of contracts meet transparency. So the challenge that legislators wrestle with every day in Canada is to balance achieving the public interest on the one hand and providing good conditions for investors on the other. The Canadian legislation is certainly far from perfect, but if you judge by the Fraser Institute rankings, Canadian jurisdictions are, I think, doing a pretty good job of finding that balance. So I think the principles and the issues that Canada is addressing and that Mongolia is addressing are actually quite similar. Very nice short summary of Canadian mining law at this website, which is prepared by the ICLG law firm, and I invite you to look at that. You may be aware that ICLG does chapters on mining legislation in all important mining countries, and they also have a chapter on Mongolian mining legislation as well.